unabashed,
the most unpredictable,
becomes a headline,
the most volatile,
outrageous behavior,
unsubstantiated narratives, a battle of personalities.
Welcome to Grant Tamasha, a co-production of the Carnegie Endowment for International Peace and the Hindustan Times. I'm your host, Milan. Over the past decade, India has witnessed significant conflict within and around several democratic institutions meant to act as checks on executive power. One of the most important theaters of conflict has been the judiciary, more specifically the Supreme Court. A new book by the legal scholar Gautam Unsealed Covers a Decade of the Constitution, the Courts, and the State, takes us through some of the most controversial cases that have come before the court during this critical decade. Gautam is a lawyer who's been personally involved in several important contemporary constitutional cases, and he's the author of multiple books of fiction and nonfiction and founder of the influential Indian Constitutional Law and Philosophy blog. To talk more about his new book and the Indian Supreme Court, Gautam joins me from New Delhi. Gautam, congrats on the book and thanks for coming on the show.
Thank you, and thank you so much for having me on.
So, Gautam, I want to ask you a little bit about the origins of this book. It brings together a set of essays that you've published over the last decade or so on your blog, the Indian Constitutional Law and Philosophy blog. And in the introduction to the book, you say that you really set up this blog for three reasons. You wanted to demystify constitutional law, you wanted to democratize constitutional law, and you wanted to popularize a readable form of legal analysis. So I'm wondering, just to get started, take us back to 2012 when you started this blog. What did the world of legal constitutional analysis look like back then?
Yeah, so back then, there were a few subject-specific blogs in India. So there was the Indian Corp Law blog that basically provided real-time analysis of developments in corporate law. And a lot of our students in law school were encouraged to write guest posts for that. So that's how I began legal blogging. There was Spicy IP, which looked at intellectual property. And there was Law and Other Things, that was a general purpose blog that dealt with legal developments in public law. And they were all very good, solid blogs that took important legal issues and did a very good job of bringing them to the public in a non-jargon language. So that inspired me to begin a constitutional law specific blog, because I thought that there wasn't a blog of that kind yet. And I was interested in constitutional law. I just finished a master's, and I thought that this would be a good way to both engage with constitutional law, as I said, democratize it, and also sharpen my own understanding of the Constitution.
I want to kind of set the stage for our listeners about where the judiciary kind of fits in the current moment. Very upfront in the book, you note that in India, judicial assertiveness tends to be inversely proportional to the strength and aggressiveness of the government of the day. And you've pointed out across your writings that this particular Supreme Court has, on more than one occasion, chosen simply not to hear cases that are politically sensitive or uncomfortable and that would put the executive in a tight spot. For people who have followed India for a long time, this sounds somewhat familiar, right? Because we are used to dominant party regimes. We had a long one under the Congress, and one that did move in certain ways to curb the influence of various accountability institutions like the court. Tell us a little bit about, what's different in your mind today than, say, the 1970s during the heyday of Mrs. Gandhi.
I think there are both similarities and differences. And as I said, the space for maneuver that the court has is inversely proportional to the space the executive gives it, and that depends on how strong the executive is. I think in the 1970s, the difference was that you had, I think, a much more direct and visible control of the executive over the courts that came through, for example, its control over judicial transfers, judicial appointments, superseding judges who were in line to become the Chief Justice. Since at that time, both the formal and substantive power of appointment was with the executive. The executive would just supersede a judge. And then that in turn led to you seeing explicit pro-regime judgments. So the classic example is that the Keshwananda Bharati case, the basic structure case, the famous one, the Chief Justice and the next three senior most judges who were in line to become the Chief Justice, all were in the majority against the government. And number 4 was Justice A.N. Ray, who delivered a minority judgment in favor of the government. And the next day, soon after, the top 3 are superseded, and he becomes Chief Justice. And then he delivers judgments in favor of the government consistently in the 1970s. That happens again with the infamous habeas corpus case involving emergency powers, where the number 2 judge, Justice Khanna, is the only dissenting judge, and he says that you don't have executive impunity, does not exist in an emergency, and he superseded. So there was a much more direct and visible way in which the executive controlled the courts, and the courts then returned pro-executive verdicts. I think now it's much more nuanced and subtle, because in the 1980s, the judiciary rested formal control over appointments, 1982 actually. And now the formal appointment system is the collegium, where the top 3 Supreme Court judges effectively appoint the High Court judges, and the top 5 appoint Supreme Court judges. And so the formal control of the executive over the appointments is now only with respect to passing the warrant of appointment. Substantively, it appears that control has been lost. So that's on the executive side. And on the judicial side, I think, as you pointed out, what you're seeing is that you don't see so much, in a very controversial or high stakes political case. Well, you have had verdicts that go in favor of the government, and you don't normally get a verdict the government loses. Demonetization is an example, Aadhaar is an example, and so on. But in many of these high-profile cases, the court does not hear them. So electoral bonds, something you have worked on quite a bit, has been pending for the last 6 years, and other cases of that kind. Article 370 was pending for 4 years, and it's just been heard right now, after the facts on the ground have changed quite a bit. So I think that the relationship of control, intimidation, response, I think was much more visible in the 70s, and now it's gone underground a bit, and you have to infer various pressures, the maneuvers, and the ways in which the court tries to carve out space for itself, and tries to retain a certain amount of space in the teeth of the executive. It's much more difficult to actually pass it out now. So I think that's the main difference.
So I want to come back a little bit later to the question of appointments, but I think a lot of ordinary Indians who might be listening today are often confused when they see the court pay such enormous deference to the government of the day, because if you rewind the clock to a decade ago, we were talking about the rise of judicial sovereignty, right, as the paper by Pratap Banumeta put it. And I think there are obvious ways or reasons for which a court may not want to cross a ruling party that's immensely popular, right? Most institutions don't want to do something that the public opinion is not in favor of. But outside of kind of stoking public outrage or popular outrage, what are the kinds of costs the court or members of the court might incur if they move to openly defy a dominant executive?
Yes, I think there are a few costs that are quite obvious. So one is, and this is the most basic one, so about appointments, right? So although the substantive power of appointment is now with the collegium, it's the president who formally issues the warrant of appointment. And the president here means the executive, council of ministers, basically. And so what we've seen a lot in recent times is a pocket veto. So the collegium's recommendation goes to the executive. The executive just does not act on it. It does not issue the warrant. And there's nothing the court can do in that case. The court has to negotiate, persuade the executive to just issue the warrant. And I think that in that sense, you see that given the judicial backlog, given the pending cases, appointments, just having judges is very crucial for the court just to have work done. And so in that sense, the ability to formally withhold your assent to an appointment is a powerful weapon in negotiating space with the judiciary. And ever since 2015, when Chief Justice Thakur was Chief Justice. There was this momentous day when he almost broke down because the government was just not issuing warrants of appointment. So that's a pressure point. Um, the government has the intelligence bureau, and the intelligence bureau, often then returns adverse findings about candidates for judicial office, and historically you've seen that often these are unfounded. But that then gets the issue into national security domain, which the court is obviously very hesitant to then enter into. So that's one quite powerful weapon that the executive has. On the other side, you have incentives. So for the longest time, there's been this critique that because the retirement age is 65, there is still a substantial part of your career left when you retire as a Supreme Court judge, High Court judge 62. And appointments to tribunals are under the control of the government. So there are various SOPs that the government is able to offer to judges, and across political parties, the opposition, whoever it's been, for the longest time, has been saying that this ability of the ruling party or the executive to effectively prolong the career of a judge by giving them appointments after their retirement is another problem that can undermine independence. So in that sense, you see that there are all these carrots and sticks that ensure that the executive continues to retain a certain degree of control or influence, with respect to its ongoing struggle for space with the judiciary. I think that is not something that is particularly atypical, because in any, I think, democracy, there is always a struggle for space between the courts and the executive, and the executive uses what tools it has to take that space. I think that's quite common. I think the difference is that in India, we are often unwilling to recognize that. And we are unwilling to recognize that the court is a political actor that is engaged in a political struggle for space. Unlike, say, the US, where it's a very clear thing, right? That the president appoints the judges, the Senate confirms. And so, therefore, the political scenario will influence how the court operates. I think that honesty is something that is perhaps a little lacking in our system, because we don't acknowledge that it is effectively a clash between political actors.
Just to stay on this question of judicial appointments for a second, so you have this small group of justices known as the collegium, which decides who gets to sit on the Supreme Court and the other relevant high courts. And the collegium, for its part, has been criticized time and time again for being opaque, for sometimes being nepotistic, for being non-transparent. If you go back to 2014, Parliament passed a bill, the National Judicial Appointments Commission, or the NJAC, to essentially scrap the collegium, replace it with a board that selected judges. But then the court, in turn, struck that down, saying that it was unconstitutional. So this tension between the executive and the judiciary remains. There was to be negotiated a memorandum of understanding between the two branches of government.
Memorandum of procedure, yeah.
Memorandum of procedure between the two. Has that been signed? If so, is one party or the other not adhering to either the letter or the spirit of that understanding? Because it seems, as you mentioned, we still are getting into these conflicts where the court may put forward a name and the executive can just sit on the name until the name gets withdrawn.
Yeah, so there was a memorandum of procedure in progress, and at some point, we just stopped hearing about it. So I actually don't know what's happening with that, because for the first 2 or 3 years after the NJAC judgment, which was in 2015, we kept hearing that this MOP is being finalized, a secretariat will be set up, and it's in progress. And then somehow people just stopped talking about it, and the court stopped talking about it. So as far as I know, it's not in existence yet as a formal document. But again, I could be wrong, because there's no information on that as such. And that would have helped, yeah. I think the problem is that it's being seen as a bit of a zero-sum game, right? So either the court has control or the executive has control. And the problem with the NJAC was that the way it was set up, it left a kind of ample scope for executive control to creep in its terms. And I think that was why the court struck it down, although the judgment was a little dodgy in terms of reasoning. I think what they were afraid of was that this was a way of getting back executive control. And the idea that you could have a commission that is multi-partisan or multi-stakeholder, as in South Africa or Kenya or the UK, where you have executive represented, the court represented, other bodies represented, with no one dominant voice. We have lost that idea in this sort of what's become a zero-sum game between the executive and the courts on who controls appointments.
I want to ask you about one of the cases that you mentioned earlier when we were talking about the judiciary showing excessive deference to the political executive, which is the case around electoral bonds, right? Which is a new instrument of political giving in which neither the donor nor the recipient must disclose their identity. So essentially, the law legitimizes kind of opacity in the system. The upshot is that the flows are flowing through the banking system rather than being processed or transacted in cash. Now, there was a suit challenging the constitutionality of that scheme filed as far back as 2018.
It was 2017, actually, 2017.
2017. Excuse me. And at the time when the court first acknowledged it, it said, look, the introduction of bonds are a quote unquote weighty issue. We don't want to act before the 2019 general election. We have to have careful deliberation, but we haven't heard much from the court since then. So, obviously you don't have a crystal ball. You can't predict what the court might do. But how do you view the constitutionality of this scheme? And what do you think are the major legal arguments that the court should be considering?
Yeah, so I think just with one point on that, it's interesting because when the court said it's a weighty issue and we don't want to, do something off the cuff, that was actually in 2019. So it was 2 years after the case had been filed. It was mentioned because the elections are coming up, general election, and then the court says, "Oh, it's a weighty issue, and so we'll postpone it to after the election." Except that it was already 2 years since it was filed, so this was obviously a completely bogus argument of the court. But yeah, so I think that
and the 2019 mention was 4 years ago.
Yeah, it was 4 years ago, and then it was again mentioned, and then Chief Justice Bobde was the Chief Justice, and then there was an interim hearing where he came up with this absurd idea that if you want to know who is donating to whom, you look at a company's entire financial record and do a match the following, and it was just completely absurd. But to answer the question, I mean, there are a number of constitutional issues with the electoral bonds, and so one thing to add to what you said, it is opaque, yes, but the interesting thing is that because the State Bank of India, it goes through the government bank. Actually, the central government has access to the data. So it's not just opaque, it's asymmetrically opaque in the sense that the central government and thereby the ruling party will actually know who gave money to whom. The opposition will not. And so if the central...
And I should mention that is the case because SBI, the State Bank of India, is a public sector undertaking.
Yeah. So actually, I mean, and since, obviously the fear of then reprisal is very much in the minds of the corporates who donate. And so it's not just opaque, but asymmetrically opaque. And there were many constitutional arguments against it. One is that over the years, the Supreme Court has developed a doctrine according to which the right to vote, the freedom of voting is a fundamental freedom under Article 19(1)(a), the free speech right. And in pursuance of that, the Supreme Court has, evolved many ideas or concepts that effectively make it a right to an informed and fair election. So it's compelled MPs to publish, assets and criminal convictions and their backgrounds and so on. So the Supreme Court itself has held that there is a fundamental right to an informed vote, which obviously you can't have if you don't know who is funding the political parties, and this model makes that knowledge impossible. And the second, of course, is the asymmetricity of it. So there's this whole Article 14 or equality argument where the opacity is asymmetrical. So I think the two main arguments are that one is that it deprives the voter of the right to information and the right to cast an informed vote, which is a fundamental right as per the Supreme Court's own doctrine, and that it's arbitrary in the sense that it asymmetrically benefits whoever is in the executive as opposed to the other players in the democratic game.
I mean, just to stick with the first argument, there seems to be a contradiction here, right? Because As you point out, the court has ruled that voters have a right to know about the biographical details of the candidates that are on the ballot. They have the right to know their educational qualifications, their financial assets and liabilities, their criminal antecedents, if there are any. Um, and in another realm, when it comes to the law and politics around the anti-defection law, which we'll talk about in a second, the court has placed great weight on the importance of voters voting for a particular party at election time, right? So if there's a right to know around candidates and parties are very important, one would think the right to know should extend from candidates to parties, no?
Yeah, and just to add to that point, over the years, we have seen a gradual shift in importance and status from the representative to the political party. And the anti-defection law, which you mentioned, is central to that. So as of now, it's far more a party vote than it is a legislator vote. Because once the legislator gets into parliament or the state legislature, they have to follow the party whip or they get disqualified. So in that sense, the party has become increasingly more important as a constitutional actor over the years than the legislator. And in that sense, this is an even greater violation by not having disclosure about who is funding the party.
Hey, Grant the Masha listeners. Thanks for listening to the podcast. Putting this show together each week is a labor of love, but it takes a lot of work to put out a great show every week. If you'd like to support the work we do at Grant the Masha, please visit ceip.org/donate. Don't forget to subscribe to us on Apple Podcasts, Google Podcasts, Spotify, or on your favorite podcasting platform, so you'll be the first to know when a new episode rolls out.
Let me just stick with elections for a second here and talk to you about another important judgment which the court did pronounce. Recently, the Supreme Court held that the selection of the chief election commissioner and the other election commissioners that make up the ECI would be done by a 3-member committee consisting of the Prime Minister, the Leader of the Opposition, and the Chief Justice of India. And that was the interim solution they had put into place until Parliament acted on its own to pass a law. Parliament did in the most recent session.
It's a bill so far.
It's a bill, excuse me. It's a bill, but the bill proposes that you would have the Prime Minister, you would have the Leader of the Opposition, and rather than having the Chief Justice, you would have a cabinet minister, which is another member of the executive. You've been very critical of this bill that Parliament's considering. Tell us why.
Yeah, so, there are many different issues here. So it goes back to the original Constitution of India. So there's an Article 324, Clause 2, that says effectively, and I'm paraphrasing, that Parliament will pass a law that will, govern the selection of the chief election commissioner and election commissioners. Until Parliament passes a law, the President will have the power to appoint these functionaries, especially the CEC. At that time, for a long time, there was just one. There was one chief election commissioner, and the President here, of course, means the Executive Council of Ministers. So the practice had always been that the President, which is in effect the Executive, was appointing the election chief election commissioner and then later on the election commissioners themselves. Now, this is obviously a problem because the election commission is the referee of the democratic game. And if one party has a right to appoint, or one player has a right to appoint the referee, that's an obvious problem. And that's why in most other countries, the election commission is either a non-partisan body or a multi-partisan body, or requires confirmation by parliament. There are many routes, but direct executive appointment is something that's very rare, and the judgment actually has a table, the concurring opinion, that shows India is an outlier in that regard. So the Supreme Court basically said that, look, the election commission is a fourth branch institution. Its entire idea is to guarantee free and fair elections, and it doesn't make sense and militates against the independence of that body if a player in the game is appointing the referee. And they said, therefore, that this present mode is, cannot go on forever. Parliament intended that there would be a law. The Constituent Assembly framers intended that there would be a law. Parliament never passed law, but therefore we'll step in until Parliament passes a law. And because the court recognized that ultimately it's Parliament that must finalize the method of appointment, they said we'll have an interim solution, and our interim solution is Prime Minister, LOP, and CJI, which they took from the CBI, Central Bureau of Investigation, appointment processes for that, which itself came through a judgment a couple of decades ago. And now the bill removes the CGI and replaces the CGI with the minister nominated by the Prime Minister. And so the problem is not so much, or it actually isn't a problem at all, that the CGI has been removed, because that was an interim solution. There is no constitutional mandate that the CJI be in that appointments body. What the mandate is, as the court held in the case, was that whatever the composition be, it must be such that secures the operational and structural independence of the body, and appointments control is fundamental to independence. And so, therefore, the new bill, its new model, reverts it back to executive control, because earlier you had the president, which meant the prime minister, the executive. Now you have executive dominance in a panel of three. So you're taking it back to the pre-judgment position where whatever the composition is, the executive dominates, and that's obviously against the independence of the body.
And essentially takes us back to this status quo where we were before this judgment was pronounced. Let's just come to the anti-defection law, because we touched on it, and it's a intricate and deeply complicated area, as you know. But just so our listeners are on the same page, the Constitution was amended in 1985, basically to stipulate that any lawmaker who defies his or her party whip on any vote will be automatically disqualified from Parliament. And this has been an area where there's been a lot of controversy. There's been a lot of case law. I want to ask you about a recent case involving the Shiv Sena in the state of Maharashtra. Without going to too much detail, let me just try to summarize the relevant points. This was a case where there was a split in the Shiv Sena, with a rebellious faction claiming it, and not the faction headed by the party chief, who happened to be the chief minister, that this rebellious faction was in fact the real embodiment of the party. And this breakaway faction claimed it wasn't defecting. It simply represented the party that should be officially recognized. Many things transpired, but in the end, the sitting chief minister, Uddhav Thackeray, resigned his position. The rebellious faction leader, Eknath Shinde, replaced him with support of the BJP, which had been in the opposition. To make a long story very, very short, the Supreme Court eventually ruled in this case, and I'm grossly generalizing here, but basically everybody acted improperly. The breakaway faction acted improperly. The governor of the state acted improperly. And yet, here we are today, Gautam, in August of 2023, Eknath Shinde is still the chief minister. Uddhav Thackeray is without a job. It seems to me that this case drives a pretty big hole through the anti-defection law, but I'd love to hear your thoughts.
Yeah, so this is, as you said, exceedingly complex, and I'll try and simplify some stuff. So there have been, the anti-defection law has been undermined for a long time now. I think it's each time politicians devise a way to get around it. What happens is that they use that way, it gets challenged. The Supreme Court says it's not right, but it's too late to do anything about it, and therefore the status quo, which has been altered, stays altered, and then next time they'd find a different way of getting around it. So this has been a common thing. So, for example, at one point, the MPs or MLAs began resigning. And so they said, we haven't voted against the party, we've just resigned. And therefore, the overall strength comes down. And so many strategies have been used. In this case, it implicates a number of constitutional actors. So one actor is the governor. So the governor is a central government appointee. And this is one of those anomalies of the Constitution, where a central government appointee sits in the state, in the state, and he or she is supposed to be a figurehead. Just like the president of India or the Queen and the governor. They're supposed to be like that. Except that what happens is that when the governor is a central government appointee and the party in power in the state is an opposition party in power, there's lots of scope for mischief. And one example is that the governor decides, for instance, after an election whom to call first to form the government. So if you have a closed election and you have a split house, then the government can decide whom to call first to try and form the government. And if the governor calls A or B, then A or B can then lure other parties saying, look, if you come with me, I'll give you a ministerial berth and so on, and then cobble together the majority. It's actually what happened in Maharashtra in the first round when the elections took place a few years ago. So the governor can influence government formation despite being a constitutional figurehead. The other thing the governor does, and this was sanctified by the court in a recent judgment regarding Madhya Pradesh, is that the governor can summon the house to call for a floor test. So if there is, a dispute over who has the majority, and a case like this where people have defected or not or are claiming they haven't, the governor can ask the chief minister to prove majority on the floor of the house. Right? And if the governor says, prove it, then that accelerates stuff. And then, as in this case, chief minister resigned because chief minister was convinced that other people, that these rebel MLAs would vote against them. The other constitutional functionary is the speaker. Now, unlike the Westminster system, House of Commons, in India, the speaker is not independent. The speaker is a ruling party nominee. And it is the speaker who is the authority which decides upon disqualification after defection. So the speaker, is the one who says, okay, you MLA have voted against the party whip, and therefore you are disqualified. The speaker can do that, or the speaker can choose not to. They can just sit on a disqualification petition and say, okay, I'm not going to act on it. And until then, that MLA, who is supposed to be disqualified under the rules, is continues in the house. So this case involved all these constitutional functionaries who are supposed to, apply the constitution, acting in blatantly partisan ways. And the Supreme Court judgment points it out. So that's the problem with that. But the Supreme Court's own role in this case is really important, and I think I'd say it's quite tragic what happened, because when all this was happening, in June of 2022, that June when this rebellion happened in the Shiv Sena, of course the matter went to court, and at that time there was a vacation bench of the Supreme Court because the court was on holiday, a two-judge bench, and they passed interim orders basically. Where they first of all stayed the speaker's hand, so they did not allow the speaker to move ahead on the disqualification applications of the rebel, or the people who said we are the real Shiv Sena but who were against the party chief. So the court said you can't act on those disqualifications. At the same time, the court refused to stay the governor's call for a floor test. There were two interim orders. The effect of this was that the governor ordered a floor test, so that had to happen. And at the same time, the rebel, or the ones who were claiming they were the real Shiv Sena Shinde faction, who were under a cloud of disqualification, were allowed to vote in that floor test. Right? And at this point, the lawyers for Uddhav Thackeray, the chief minister, said, look, what you're doing is that if it later comes out that these people should have been disqualified for going against the party whip, you would have allowed them to vote and bring down a government while they were disqualified from doing so. So you can't pass this interim order. And at this point, the court says, don't worry. If that happens, the clock can be set back. And this is actually, this is orally said in the court, and you can check, there's no transcript, but the reportage around the court. So the court said that, look, don't worry, we will turn the clock back if we have to. So then this happens, and then the chief minister resigns. 1 year later, the court hears the case, and the court says, look, yes, you were actually right. This should not have happened in this way, but you resigned, and therefore we can't turn the clock back. Right? So, what do you say, right? So this is, effectively, and this is a strong language, but the Supreme Court's interim orders were responsible for a government falling and a new government coming into power, which in itself the court recognized later on, was should not have happened. So I think that's the case where you see what we began this conversation with, that the courts delaying, of hearing substantive cases has an impact, a very real impact on people's rights, obligations, the political situation. And to add to that, the court giving these 1 line, 2 line interim orders, without substantiating, has a massive impact on just the country's politics. And unlike, a fully reasoned judgment where you have all the reasons, given, you can critique the reasons. A 1 line interim order, you can't critique it because there's no reasoning attached to it. So that's a separate problem with respect to how the court engages with these kinds of disputes.
I mean, Gautam, just thinking about what you've said, just to summarize for our listeners, is you have this very stringent law which says if the party leader says you must vote this way, and the lawmaker decides not to, he or she will be disqualified. But there are all of these loopholes. There is the resignation route. You can say, well, no. Before you can disqualify me, I'm going to resign, and then I'll recontest in a fresh by-election. There's now this Shindefaction route, right? That the speaker can sit on. I mean, there's various shenanigans. It seems to me that politicians will always try to game the system. And the cleanest way of managing this actually is to withdraw the anti-defection law and to repeal the anti-defection law. I mean, is there a way out of this?
Yeah, I think that's a good point, and that discussion often happens. The problem, of course, as you know, is that before the anti-defection law, there was a situation where you would cross the floor in the morning and cross back in the afternoon. So then what you're doing is effectively ensuring that, the party with the maximum amount of money, and control over the instruments of coercion, will have completely free right. And that is the executive, whoever it might be. So, whoever is the party in power will have even greater control in that case. So I think that this is one of those situations where the anti-defection law is more the symptom. If you say had a judiciary, for example, that would come down hard on any attempt to weaponize the investigative agencies, against opposition politicians. One very easy coercive tool in the armory of the executive, which is that to threaten politicians by saying that we'll put you in jail under this draconian law and you'll never get bail for 2 years, that wouldn't be available. So I think there are multiple issues that have to be dealt with simultaneously, involving, the instruments of coercion that the executive has, the courts, enforcement of or ensuring that political coercion cannot be used through legal weapons, and election funding. So I think that all these come together. So without tackling those, anti-defection, being there or not being there, ultimately is not going to make a big difference.
Right. I mean, you're just going at the symptoms rather than the cause of the disease itself or the cancer.
Yeah. So why does an MP or an MLA defect or change loyalty? Either because it's well, 3 reasons, right? One is genuine ideological difference. So let's keep that aside. Second is monetary incentives or the incentives of power or opposition. And the third is coercion, or the threat of going to jail. It's 2 and 3. You have to tackle in various ways, involving how the courts act. If the courts, as I said, the courts can, refuse to issue, a sanctioned police remand. The courts can grant bail. I mean, the courts can ensure that you can't exercise coercion. They don't. So you can tackle these multiple things, I think, together for it to actually, have a functioning democratic system in that sense.
So Gautam, let me bring this conversation to a close by asking you about one last very important and very complex subject, which is the right to privacy. So there was this famous judgment known as the Puttaswamy judgment, in which the Supreme Court held that the right to privacy is protected as a fundamental right under the Constitution. Many analysts have been coming back to this judgment in recent days and weeks in light of Parliament passing a new personal data protection bill in the most recent session of Parliament. This bill does a lot of things, but one of the things it does is provides a framework for data privacy, but it gives the government unilateral discretion to exempt itself from those data privacy requirements in the interest of national security. So if and when the government chooses, it can essentially give itself a waiver to exempt itself
or
from the
any
law.
agency under its control. It can exempt any agency under its control from the operation of the act.
So correct. So, as you think about this and you put your kind of, constitutional scholar hat on, to what extent do you think this is going to pose a fundamental challenge to the now constitutionally protected right to privacy?
Yeah, so I think it's again the same thing. So in that famous case, the Supreme Court said that there is a positive obligation upon the government to bring, or the parliament to, bring into force data protection law, because privacy is something. So of course, at the level of the surveillance, it's an individual right, but at the level of data protection, you have to have an infrastructure to protect the right, which can only happen through legislation that sets up a data protection, board and all of that. So that's what the act tries to do. The problem, of course, is that on multiple levels. One is that the board itself is under the control of the executive. So we're back to the election commission issue, where a body that's supposed to enforce a fundamental right, often against the executive, is under executive control, the fourth branch institution under executive control. You come back to that problem. The second, of course, is these wide spaces being carved out for surveillance and the ability to exempt agencies or itself in the cover of national security. Now, the way that other data protection laws get around this or tackle this is by having certain principles in place. So one, for example, is data minimization. So you collect the minimal amount of data necessary to fulfill a legitimate state purpose. The other is purpose limitation. So if you collect data for a specific purpose, you cannot then use it for something else. The third is proportionality. Right? So there must be a relationship of proportionality between the data collection and your purpose. One essential prong of that is something called necessity, which is that you only collect when it's necessary, and if there's any less intrusive way to achieve the same goal, you have to use that way. Now, all these principles ought to be baked into the act, so that when there is a challenge to data collection or surveillance in any form, the courts can then invoke those principles to assess the legality of that data collection or surveillance or whatever. Or the absence of those principles being codified into law, then effectively is where the constitutional problem lies. Because then, under the terms of the act, the authority of data collection, processing, and so on is excessive. Right? So there's no legal standard that then constrains it. So that's the essential problem with the act and the way it's framed right now.
My guest on the show this week is the lawyer and legal scholar Gautam Bhatia. He's the author of the brand new book, Unsealed Covers, A Decade of the Constitution, the Courts, and the State. Gautam, these legal issues are weighty, to borrow a phrase from the Supreme Court, but also quite intricate and complex. Thanks so much for the blog, for the book, and for taking the time to walk us through the issues.
Thank you. Thank you so much. And I hope this was interesting.
Grant Tamasha is a co-production of the Carnegie Endowment for International Peace and the Hindustan Times. This podcast is an HT Smartcast original and is available on htsmartcast.com. You can also find us on Apple Podcasts, Spotify, Stitcher, or wherever you get your podcasts. Don't forget to rate and review. It helps others find the show more easily. For more information about the show and to find the writing we reference on this week's episode, visit our website, granttamasha.com. Production assistance comes from Nitya Lab. Tim Martin is our audio engineer, and Isabel Villegas is our executive producer. Thanks for listening, and see you next week.
This was a Hindustan Times production, brought to you by HT Smartcast.
HT Smartcast.